In this video, I'm going to be teaching you how to avoid getting caught in a lie at your restraining order hearing. My name is Veronica. I'm a domestic violence defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. I'm also the creator of a course called Defeat the DVRO, in which I teach you from start to finish everything that you need to know to represent yourself at your restraining order hearing and win. Because the thing about these hearings is that you can represent yourself and win, but only if you know what to do. So that's exactly what I teach you in the course, and you can get your free first class in the course via the link down below. Okay, so let's jump right in. How to avoid being caught in a lie at your restraining order court hearing. Obviously, you could just not lie, right? And I know that there's somebody who is typing up their comment and was really excited to write that down. But hold on, because I've seen plenty of people not necessarily lie, but getting caught in an inconsistency that maybe is just a mistake and doesn't actually mean that they are lying, but the judge might just take it as a lie. And if you get caught in an inconsistency that the judge believes is because you're lying, then you're probably going to lose your restraining order hearing. Let's talk about 3 examples that can get you, if you're lying, get you caught in a lie, or get you caught in an inconsistency by mistake. Number 1, text messages or emails that are inconsistent with your side of the story, with your version of events. You may be thinking, but I'm not planning to use any text messages or emails. Okay, but the other side has all of your text messages and emails, right? However the two of you communicated, they have those. And as a lawyer, I use text messages and emails that people probably forgot that they sent all the time against them in an effort to demonstrate to the judge that they are inconsistent, and they're inconsistent because they lied. So I recommend that everyone read their text messages and read their emails like a book. Make sure that you don't get surprised at your hearing. Number 2, social media photos. This is another big one where, as a respondent's attorney, I tend to find a lot of photos of a lot of posts that I can use in my client's favor and against the petitioner. If you say that the respondent, for example, hit you in the face on a certain day, but you posted a selfie the next day and your face looks fine, then you should be prepared to explain that. So if I was a petitioner, I would look through my timeline, and if I posted anything like that, I would be prepared to explain why. Maybe I used a filter, right? And in that case, I want to have the original image ready, and I want to bring it to court with me in case this comes up. Maybe I just am really good at makeup. Maybe I posted this in advance. Maybe it's a later gram. So look at your own social media. Look at what other people have tagged you in that you may not have noticed. Maybe they posted a photo from something that had been much earlier, and make sure that you are ready there. Number 3, exaggerating. Now, I see this a lot in the petition for the restraining order. One of the questions that it asks after it asks you to describe the most recent abuse, past abuse, it asks how often this type of abuse occurred. And you may be tempted to say every single day, every week. You may be tempted to exaggerate a little bit because you want the court to grant your petition for a restraining order. If you are saying that some physical act of abuse occurred every single week, then I'm going back to social media to see what pictures you have and to see if that type of physical injury is present on any of them. And if it's not, then I'm going to use it against you. Also, depending on what the allegation is, let's say it's an act of physical abuse. If you didn't get medical attention one time, you didn't call the police one time, you didn't tell anybody about it immediately one time, that probably can be explained. That's believable. A reasonable person might do that. But if you were saying that something is happening weekly or daily and you told no one, you never got medical treatment, you never called the police, you never really did anything about it, it's possible, right? It's happened, but it makes you less likely to be believed. So unless that is actually true, unless it really did happen every week or every day, or however often you are saying that it happened, don't exaggerate. It does not help you, and it can really hurt you. I hope you found this video helpful. And look, if you are planning to represent yourself at your restraining order hearing, you can keep browsing YouTube, binge watching videos, hoping to find the answers or get them delivered to you on a silver platter, which is exactly what I do in my course. I mean, I think the hardest part about learning something new, about learning a skill, is that you don't know what you don't know, right? So you may watch a whole bunch of videos. You can watch every video that I have on YouTube, but first of all, that will probably take you a long time, more time maybe than you have before the hearing. And secondly, you may still miss things. You may miss something big because you don't really have a checklist. So, having a checklist and having succinct course material that teaches you what you need to know is exactly what you need to win your restraining order hearing. If you did find this video helpful, please don't forget to like, subscribe, ring the bell, and follow me on Instagram, TikTok, and Facebook.